How do financial disclosures work in divorce? We get this question all the time, and there are different variations of it. Sometimes it's, do I have to disclose this? Do I have to disclose that? And the answer is yes, you have to disclose. It's very dangerous not to. In terms of how specifically the disclosures work in divorce, first, anytime a divorce is filed, there is what's called automatic discovery in Massachusetts, meaning that the parties have to exchange 3 years worth of certain statements, including bank statements, tax returns, information about medical insurance, and some other documents. So you get the mandatory discovery in place. That's supposed to be exchanged. And then from there, each side can drill down on exactly the information that side needs. So you take a look at what needs to be accomplished in the case, the specific information that is needed, which documents do you need to corroborate certain numbers, and you can tailor your requests to specifically what you need. So your attorney can draft interrogatories asking questions that the other side has to answer under oath. Your attorney can also craft a request for production of documents, asking for specific documents that you need. You can also do depositions where you sit the other side down and ask them specific questions. So the possibilities are pretty much endless. You just have to make sure that you're doing a cost-benefit analysis to figure out what you need and how much it makes sense to spend on those items. A lot of people can get really crazy about financial disclosures and ask for a ton of information and a ton of questions and just spend a lot of money on legal fees unnecessarily. So you got to make sure that what you're doing is targeted, that you're asking very specifically for what you want, and that it's cost effective to engage in that. So that's how basic discovery works. In addition to that, both sides have to complete and submit to the court financial statements. Very important document. It's essentially a snapshot of the parties' finances. Each person has to fill one out. Usually people work with attorneys on filling these out. It's such an important document. And it's what the judge looks at essentially when making a decision on anything related to finances. And it's also a document that needs to be submitted to finalize a divorce. You want to make sure that you are honest, transparent, and thorough on your financial statement. If you are not, then you are going to raise, potentially, you are going to raise credibility concerns with the court. And the last thing that you want is a judge thinking that you are withholding information or not being entirely honest. So make sure that you're thorough, make sure that you work with your attorney, provide more information, err on the side of caution. More is better. And then you can work with your attorney on figuring out how exactly you're going to transmit that information onto the financial statement. So that's how financial disclosures work. If you have any other questions, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com, and you can find us on all the social channels at Farias Family Law. Thank you. Have a good day.